The broadcast is now starting. All attendees are in listen-only mode.
Hello and welcome to our National Road Safety Partnership Program today, legal implications on a worker using their own vehicle for work purposes. So this webinar is proudly brought to you by the NRSUP, and today we're talking about how grey fleet, which is a term commonly used to describe the work use of any vehicle not directly provided by an organisation that employs the driver. So we've got some exciting discussion ahead today. Next slide, please, Tanya. So my name is Jerome Carslake. I manage the NRSUP and its many activities. To find out more about the NRSUP, please visit our website. We do have another colleague joining us today, we hope. We're hoping to have Darren joining us. We're just having some technical issues or trying to find him up in Queensland at the moment. Darren is a recent addition to the NRSUP and helping out and was a key author and guide in developing the Grey Fleet Guide, which we have online, and is an expert in the fleet safety space. So welcome in advance of you coming and joining us soon, Darren, whilst my colleague Rosemary sorts everything out for you on the technical side. But today, our next person is, our presenter is Associate Professor Tanya Lehman. So welcome. Tanya's current research interests include automated vehicles, blockchains, disruption in the legal profession, artificial intelligence, legal tech, and the future of legal education. She's a director of the Flinders Blockchain Alliance. Wow. And she is a member of the legal subgroup of the Australian Driverless Vehicle Initiative Policy and Risk Group. So it's fantastic to have you on with us today, Tanya.
Thanks very much, Jerome.
So to give you a bit of an outline of what's ahead of us for today, we have a session which will run for approximately 60 minutes. Our main aim is to have lots of discussion during it. And we'll be recording the session as well, which will be shared on the NRSUP website. So the structure we're looking at is around 45 minutes with 15 minutes question time. We have got a range of slides pausing through it all, but if there's a burning one that comes up, I'll try and jump in and ask Tanya where it's relevant. So, and how will you actually contribute to it? We have a great little box here. Please take the time to write your questions in and we will throw them to Tanya. So let's get started.
Thanks very much for your attendance, everyone. Because I'm a lawyer, I will start with this disclaimer that our webinar today is not providing specific or general legal advice. It's about legal information and it's only providing a summary and general overview of the matters. And as we go through today, you'll hear me say over and over again that the legal implications will be very dependent on jurisdiction and context, and so there is not necessarily a clear answer, so it is important that I give this disclaimer. So thank you for your time, and I hope that this will be an interesting session for you, and I do welcome your questions. What we're going to be looking at today, I'm sure many of you will be aware of some of the key definitions in this area, but it is important that we touch on them again. I wanted to briefly point out what's happening elsewhere in the world and then work through some areas of risk. I'm not going to give you solutions, but I'm going to be signposting some of the issues for you to start thinking about in the context of grey fleet. And then towards the end, we're going to be touching on some of the emerging issues that have arisen as a result of new developments in our economy. So the importance of the share economy or the gig economy and how people are using their vehicles differently, how people are engaging in the workforce differently, and also the increasing importance of data and the privacy issues that that raises. So what do we mean when we're talking about grey fleet? This is a term that's not necessarily included anywhere specifically, but for our purposes today, we're going to use it to mean vehicles that are used by business but not owned by the business, vehicles that are owned and used by workers to conduct the business, and vehicles that are hired occasionally and used for business purposes. So a fairly expansive definition, and this term grey fleet has come to represent all of those. Worker, that term has been defined very differently in lots of different legal contexts. There's a very expansive definition in the Work Health and Safety Act, the Commonwealth legislation, which is the basis for the Uniform Australian Work Health and Safety legislation. And I'm sure many of you will be very familiar with that term, but it is important for me just to notice here that worker not only includes what you'd expect employee or contractor or subcontractor, but also includes outworker, apprentice or trainee, a student gaining work experience, a volunteer, or other specifically prescribed persons. So why should we care about grey fleet and the implications for businesses and workers? Again, you might be familiar with these statistics, but it's important to put a human face on what we're talking about today. Nearly 3,500 workers lost their lives in that 13-year period in work-related incidents, and 39% of those fatalities were due to vehicle collisions. So we're talking about over 1,300 people killed. And of course, that's just the fatalities, but we know that many more workers and other people would have been injured in those motor vehicle collisions. The importance of grey fleet is something that's really been highlighted in the UK, and there's by some recent legislation which I'll come to in a moment. And so there's a lot more data that's available about the UK situation. 40% of work vehicles in the UK are grey fleet vehicle, 14 million grey fleet vehicles in use, and 9 million of those vehicles are used on a regular basis. Now, it's not clear whether grey fleet use in Australia is comparable, but even if it's somewhere along those lines, we're looking at a very significant number of vehicles that are being used for business purposes, but owned privately by workers. And the thing that's brought this into sharp relief in the UK was the passage in 2007 of the Corporate Manslaughter and Corporate Homicide Act. And that imposes a very explicit statutory duty of care in relation to the use of any vehicle, and potentially imposed statutory liability for corporate manslaughter or corporate homicide on organisations. And so that then brought organisations, corporations, partnerships, trade unions, employers associations, and a number of others that were specifically prescribed. So the duty was imposed in connection with the use or keeping by the organisation of any plant, vehicle or thing. And that use there extends out this liability to use of the grey fleet. The EU has also picked up on this in their framework directive and has imposed a requirement to undertake a risk assessment, and you'll see there's a link in my slide there to some of the material that they've prepared. So where does that leave Australia? Well, there are no explicit references to grey fleet in any legislation that I've been able to find during the course of my research, but there are a number of other existing obligations which do have grey fleet obligations in the work health and safety space, in the workers' compensation space. We need to think about how it might interact with liability under compulsory third-party schemes. Licensing of drivers is an interesting issue, and how claims potentially on the basis of common law negligence might apply. And of course, then we have the heavy vehicle national law if we have workers who are using their own heavy vehicles for business purposes. Now, NRSPP has been doing some great work in this space, and I'd refer you to their website. They've developed a number of 1 or 2 page resource overviews and checklists, and they are a fantastic way for thinking about how some of these issues might impact on your organisation, on your business, and help you to start thinking about not only assessing but managing risk. And I also refer you to the guide, Grey Fleet Safety Management Guide, which Darren and Jerome have developed. And also, if you want some more detail on some of the specific legislation that I'm referring to today, the publication Grey Fleet Legal Implications for Business, again, they're both available on the NRSPP website. So, if we can move now into some of these areas of risk. So let's think about work health and safety, and particularly whether or not the vehicle is a workplace. So for the purpose of the Work Health and Safety Acts, which are uniform across 7 jurisdictions in Australia, workplace is a place where work is carried out for a business or undertaking and includes a vehicle. In Victoria and Western Australia, two of the jurisdictions that haven't adopted that uniform legislation, their relevant legislation also includes definitions of workplace which extend to a car, truck or any other vehicle. In Victoria and in Western Australia, a workplace means a place whether or not a vehicle. So we know that for the purposes of work health and safety, what happens in a vehicle, irrespective of who owns it, is part of the workplace. And that engages then certain duties. That legislation in its various forms provides that persons conducting a business have a duty to ensure, so far as reasonably practicable, the health and safety of workers and other persons. And I'm sure you're absolutely across all of your obligations under work health and safety. What I do want you to think about today, though, is given that a vehicle is a workplace, what implications might this have for maintenance of vehicles that are owned by workers, not by the business, and yet used by those workers in the course of their business? What if you know that workers are using their vehicles to travel between work sites? The organisation might have a campus at one place and workers regularly travel between those campuses, or they might be using their own vehicles to drop off the post at the post office or travel down to the bank to do the banking. What if their vehicles haven't been properly maintained? What if the service schedule hasn't been followed? What if their tyres are bald? What if their vehicle, in fact, is a vehicle that doesn't have many of the current safety features? That vehicle potentially comes within the definition of workplace, provides a duty on people who are conducting the business. How far might that extend to thinking about what has to happen with those privately owned vehicles? What about travelling times? Vehicle as a workplace, potentially workers are moving from different locations under strict time limits. Again, think about the implications that that might impose, where you have a worker who's travelling in their own vehicle, they've worked at one place, perhaps for a few hours, that shift finishes, they need to travel to another place. Do they have adequate time to move between those locations? Many of the late model vehicles that are now being released and are in fact on our road have very sophisticated safety features. I'm thinking about things like lane assist or parking assist, or the number of airbags that they might have. If you are aware that workers are using their own vehicles for business purposes and yet their vehicles don't have those safety ratings and features, what does that mean about whether or not the person conducting the business is doing what they can so far as reasonably practicable to ensure the health and safety of those workers? Particularly if you might have a young employee who's driving a very cheap vehicle that has almost none of the more recent safety features, and you know that they're using that vehicle for various business purposes. Are you fulfilling your duty so far as reasonably practicable to ensure the health and safety of your workers? Thinking too about driver training. Some of these new safety features require drivers to understand what those features are. If drivers are driving in those cars with those features, do you know whether they've had the appropriate training? The appropriate training to drive engaging features like lane assist or assisted braking or some of the cruise control features. Should you know, think about what that might mean. In other parts of the world, monitoring devices like alcohol interlock devices are available widely on cars. In Australia, for various reasons, a decision has been made that those are only imposed on people who've been convicted, or generally only imposed on people who've been convicted of criminal offences involving alcohol and driving with alcohol. But if you're aware that your workers regularly go to the pub or have some drinks after work and then might use their vehicle to make deliveries or something on the way home? Do you need to think about some sort of monitoring devices to ensure that your workers and other persons are as reasonably safe, as safe as reasonably practicable? If we move on now to the workers' compensation area, and again, I'm sure that many of you will be very familiar with this area and managing risks. It's important to recognise before we go into this area at all that the definitions of worker for this purpose will vary across all jurisdictions, and so it's very important for you to look very closely at the legal obligations which apply in your jurisdiction. A common term that has significant implications as to whether or not persons who are injured during the course of work might be eligible for workers' compensation is this notion of an employment-related journey. In Victoria, if drivers are carrying passengers for award or they are owner drivers carrying goods for award, both of them are deemed to be workers for workers' compensation purposes. And then we need to think about whether or not the journey that they're engaging in is an employment-related journey. And there's a number of cases that deal with interpreting this phrase. In New South Wales, for example, there's got to be a real and substantial connection between the employment and the accident or incident out of which the personal injury arose. And each jurisdiction has its own definition. So when we're thinking about this in the context of grey fleet, we're thinking about workers who are driving their own vehicles for journeys that may take them from their home to their workplace, may take them from their workplace to another workplace, may take them from their workplace to the pub, may take them from their workplace to the bank or to various other places. When will a worker driving their own vehicle be making an employment-related journey? So eligibility will be important at this point. If a worker is making an employment-related journey, then some of the issues that I referred to on our last slide, thinking about worker health and safety, also become very relevant here. Does the employer or the person carrying on the business have knowledge about the maintenance of the vehicle that the worker is using? Have they ensured that the worker is following a service schedule? And in fact, can they or should they interfere with how workers choose to maintain their own vehicles? What if a person conducting a business can see a vehicle in a parking lot and has sincere doubts about whether or not that vehicle is safe to be using or not? Same comments that I'd make in relation to travelling times and safety ratings and features. Now, I've used this as a separate slide thinking about workers' compensation because it may well be that if for whatever reason a worker is driving their own vehicle, is involved in a motor vehicle accident and cannot establish that they are eligible for workers' compensation because it's not regarded as an employment-related journey, then they may well have more incentive to consider whether or not there are some claims for breach of work health and safety obligations under the legislation, or whether or not there is a negligence claim that could be made against some other person, including potentially the business owner or organisation. And that's particularly in the context of unsafe systems of work. Again, I want to stress here, eligibility for workers' compensation and the definition and how it's been interpreted of employment-related journeys will be very jurisdiction specific. So let's think about emerging issues in the context of employment-related journeys and ride sharing. So what if we have a situation where a worker is being asked to travel across a major city from one work location to another work location, and they have a late model vehicle. They've also registered with a rideshare service, and they operate as a driver for a rideshare service out of work hours. And they make the assessment, it's going to take me half an hour to drive from one side of the city to the other. They post the fact that they're doing that and see whether there's any member of the public who might want to pay for a rideshare service for fee while travelling in that vehicle. Now, that raises some really interesting questions about whether or not that is an employment-related journey, whether or not that person, the worker who's travelling in their own vehicle to get from one business place to another, but is also providing these rideshare services, whether that is something that still is the responsibility of the organisation or not. Should the business and the organisation have a discussion with their workers that either requires them to refuse to advertise rideshare services, or refuse to or precludes them from advertising rideshare services within a particular time frame, or whilst they are travelling on other work-related business. So these are important issues for you to think about. Ride sharing, whether it's with Uber or Lyft or GoGet or other formal ride-sharing services, is one thing. There are other informal ride-share services, and it would be worth organisations thinking carefully how they manage their liability in that context. So, questions. Jerome, have we got any?
We do indeed. We do indeed. And I believe Darren's joined us now as well.
Hello, Darren.
I can hear you, mate. So, question for you here. I've got one here for Frank for you, Tanya. Why is the UK data better? Is it because of the Corporate Manslaughter Act? And if so, does Australia need this?
Absolutely. I think the Corporate Manslaughter Act focused people's attention very urgently on finding out what their organisation's grey fleet use was, and a collection of that data has given rise to the information that I've cited. But when that legislation came in, because of the potentially very, very serious consequences for business owners and directors, they needed to exactly know what was happening, and that's why that data is a lot firmer than ours. Whereas we haven't had the same focus. There is not the same clarity around vehicle and the potential for liability for manslaughter and homicide, and so I think there's been less intensity in needing to find out that data.
Do you think that our third-party insurers have picked up a bit more of a tab on workers that are injured on the road?
What do you mean by a bit more of a tab?
Well, I guess if someone's injured and they're driving and they're not really picked up under a workplace scheme, they pick, like in Victoria, would CTP pick them up as TAC pick them up as an example?
Yes, absolutely. I'll come to CTP schemes in a moment, because eligibility for those schemes varies widely across Australia. It might be that for whatever reason, schemes that require fault to be proved in relation to CTP might mean that a particular driver is not eligible. So in Victoria, where it's a no-fault scheme, there might be quite different considerations about the intersection between workers' compensation and CTP claims than there are in some of the other jurisdictions. So I'll come back to that as we go through.
Excellent. Another question here from Henry. So Henry wants to know, how far does a grey vehicle go? Does it include an electric bike?
Well, potentially it could. It might even include not only an electric bike, but it might include those young men that I see riding their bicycles with the big Deliveroo pizza boxes on their back. If we think about the definition of vehicle, what is vehicle for this purpose? I would suggest that anything with an electric motor is clearly a vehicle. Anything with a motor, whether it's electric or combustion, is clearly a vehicle. I might be an argument that if your business model is built on the fact that people are using bicycles and you are expecting them to use bicycles to get from A to B, and you know that they don't know how to maintain those bicycles, or the bicycles are not safe, then again, it might be possible, given a creative lawyer, to push out grey fleet liability to bicycles as well.
Thanks. And I got one question here from Sarah. How far do you go with regards to safety features on a vehicle? So balancing safety versus cost.
Well, that's a very interesting question. Some of the most of the most recent models of vehicles have excellent safety features. The question is, who owns the vehicle and what control does an organisation have on requiring the purchase of certain vehicles? So this is beyond the scope of this webinar, but if we're thinking about businesses, I think it would be wise for businesses to think about making sure that vehicles that they purchase have as many of the latest safety features as possible. The question becomes, though, in the context of grey fleet, your employees might not be in a position to purchase those vehicles, which are often very expensive, particularly younger workers or workers who are not earning a lot of money, or even people who are earning a lot of money may choose not to spend that money on their vehicle. Now, what control does an employer have over whether a worker uses their own vehicle for work purposes when the employer or the organisation knows that that vehicle doesn't have airbags, has got bald tyres, is blowing a lot of smoke, one of its indicators is not working, those types of things. I think that's a very dangerous area for organisations, and I would say that I think it's wise for organisations where they can, and they know vehicles are going to be used for work purposes, to make sure those are vehicles owned by the organisation rather than relying on workers to use their own vehicles. I know that's an added expense, but it comes up about assessing and managing risk.
Great. Last question here before we move on. And Darren is trying to connect in. He's just pulled over on the side of the road and having some issues. Would Uber drivers be part of this? Would they be classified as employees?
Well, there have been a number of cases in different jurisdictions now around the world as to whether or not Uber drivers are classified as employees. I haven't read them all in detail, so I'm not across all of them. But what I would say is that people might be classified as employees for tax purposes and for WHS purposes, but perhaps not for eligibility for workers' compensation. I haven't read in detail the Uber standards for vehicles, but my understanding is that they tend to approve only relatively late model vehicles, which may be a way of managing their risk in this area. My concern's not so much with Uber, but with other persons who offer ride sharing for fee, because they're less likely perhaps to even have to go through Uber's eligibility standards, if you like, about the state of the vehicle. So, for example, my institution encourages our students and staff to carpool and provides financial incentives for doing that. Most students don't drive expensive cars. Many students drive cars that probably are at risk of being defected. Those ride sharing issues do raise some very interesting work health and safety issues and very interesting grey fleet issues. Are they workers? Are they not? All of these things need to just be thrown into the mix and think carefully about it. So I think the takeaway at that point is if an organisation knows that employees are ride sharing with their own car, then the question becomes whether they're doing that on work time or whilst also using their vehicle for work purposes. And I think at that point it's the time for the organisation to have a conversation with that worker and say, no, you shouldn't be doing that. And again, look to see how you can get workers in work vehicles when they're doing work business.
Right answer. Well, if you want to move on, please, I'll hold the other questions over to our next pause, so thank you.
Okay, so we've just touched on this briefly in some of the answers that I've just given. So compulsory third-party schemes are not nationally consistent across all Australian jurisdictions. And why is this relevant to organisations and their workers? And I think that, as I've just said, if somebody is injured in a motor vehicle accident and for whatever reason they are not eligible for a CTP scheme or not eligible for some other compensation, then they might have more incentive to think much more creatively about where they could access some form of compensation or legal remedy. And so there are these intersections there with work health and safety, with workers' compensation, and potentially with obligations on directors, which I'll come to later. So some of our jurisdictions in Australia require drivers who are injured and who seek compensation to prove fault, which means they have to prove that somebody else was negligent. Some jurisdictions like Victoria don't require that, but then they have other eligibility criteria which relate to motor vehicle accidents. If we're thinking about proving fault, and we're thinking about who should be a potential defendant, in addition, perhaps, to a compulsory third-party insurer, issues around organisation or employer knowledge regarding the safety of vehicles, I think, potentially could become important, particularly around the knowledge of maintenance of vehicles. So if we're talking about an organisation that regularly requires workers to use their own vehicles for particular purposes, this is not just the once-off that the employer is not familiar with, but the employer knows that every Thursday night, worker A takes the takings, banks them, then goes to the post office, does this, does that. And they know that the vehicle is not been maintained, has got bald tyres, can see that it's got bald tyres, etc. I think potentially there is risk there. How it intersects with various schemes will be very interesting. But if injured persons can't make a claim under a CTP scheme, that gives them a whole lot of incentive to pursue these other options. And as we've already talked around, safe travelling times. Are we giving workers long enough to get where we expect them to go whilst travelling completely at the speed limit, taking into account traffic jams, etc., etc. What is it that we know about safety ratings and features that are available on late model cars, and why are we allowing workers to get into cars that don't have those models? Licensing of drivers is a very interesting issue. A lot of young people work in roles that often require them to use either their own vehicles, and I'm thinking here about motorcycles, bicycles, or their own cars, for doing things like deliveries, pizza deliveries, Uber Eats, Deliveroo, etc. And many of those young drivers either hold P plates, they might have conditional licenses, and increasingly we are seeing international students in this space, often, sometimes, driving on international driver's license. If a business or an organisation knows that it is engaging a particular person to use a vehicle for business purposes, have they taken the time to check that the licence of that driver is appropriate? So conditions that might apply on licences might be relating to the time a vehicle can be driven. So there are restrictions on young drivers driving between the hours of midnight and 5 AM. There might be restrictions on how many people can be in the vehicle with that driver. There might be restrictions on the vehicle type. So they might only be able to ride motorcycles of a particular capacity, for example. It is really important for businesses to think carefully that people that they are getting to do work for them, who are driving in the course of that work, have the appropriate license for that work and for the use of the vehicle that they're being asked to do. It's something that is reasonably easy. In the context of charities, though, this also raises another very interesting question. So I'm thinking now about charities like Meals on Wheels or other aged care charities where you have perhaps retired people who are volunteering to be companions or visit people who are shut-ins, and they use their own vehicles for that. Now, as our society is aging, we've got an increasing number of older drivers on the road. Some of those older drivers have issues around wearing glasses, around night driving, around age impairment. Again, for those types of agencies to think really carefully about who their volunteers are or who their employees are. Do they have the current license and in fact the current license driving skill to be doing the driving that is required as part of that organisation? So many older people.
On the skill, how important is it? Because it's easy to get a license, but how does an organisation make sure the driver has the skill?
Well, that is very challenging. If let's take a Meals on Wheels type scenario where you might have a person in their 70s who has volunteered to deliver those meals and who regularly turns up in their own vehicle that has a few extra dings in the rear bumper, and that driver has difficulty navigating in and out of the organisation's car park, drives perhaps very slowly. I'm sure we know the types of drivers that we're talking about, and the organisation doesn't have a conversation with that person about what their licence conditions are, if any. I think there is some potential risk there, and I think it would be wise for everybody, for those types of organisations, to think carefully at the end of a person's driving life cycle as well as at the beginning, to make sure that they do have the skills. I mean, many of us see elderly people who are driving in ways that we wonder why they're still on the road, and yet often they are doing very, very valuable community work as volunteers for organisations using their own vehicles. I think it does create a risk. Any other questions on that while we're there?
There is one here from Darren. What if P-platers do not adhere to licence restrictions? What can the company do if they are unaware but presume they will comply?
Well, I think the key word there that's problematic is presume, and that is, you should never presume. That it should be part of explicit instructions, whether as part of the contract or code of conduct or employment policies, that people who are using their vehicles for work purposes or using a work vehicle for work purposes are required to comply with the road rules. I think it's problematic if that conversation has never been had. If the conversation has been explicitly had, organisations can't be out with every employee on the road wherever they are, but so long as they've had the conversation, I think that's important.
Right. A question here from Ahmed. Should all companies mandate a certain safety level or late model vehicle? If so, what evidence is there about how old they should be?
I'm not the best person to answer that question, because I'm not a person who has expertise in vehicle safety, but there are a number of people around who absolutely can tell you exactly how much safer some types of vehicles with some types of features are than others. I think there's a really tricky issue here for organisations, in that those vehicles inevitably cost more, and And so by mandating a particular level of vehicle, potentially that's imposing a lot of additional cost on organisations. Now, that has to be assessed and balanced with the risk that there might be other liability that might be found to rest with that organisation if they are requiring people to use their own vehicles, which when those vehicles clearly have some issues around their safety. So that might, in the longer term, be a more risky proposition.
Okay.
So there are many fleet managers who can give good advice about safety levels of vehicles, I would have thought.
And sort of comment here from Darren joining in as well. We need to stress and make sure that organisations, you really need to actually document all your systems and process relating to these issues such that you can really ensure you're complying with your licence restrictions.
Absolutely.
And great point here from Naz. Is it enough to check the driver's licence with no visibility of the demerit status?
That's an interesting question. I think it might be useful to ask the employer to disclose what their demerit status is, and then at least you've asked the question.
Last question before we move on. One here from Duncan. Sorry, I'll quickly add on this point. A point is this comes from Ben. A declaration is recommended from an insurance perspective. So thank you for that, Ben.
Yeah.
Duncan asks, an employee's vehicle needs maintenance, but the employee can't afford it or is unwilling to put the vehicle in for service. Who pays? How does that impact liability?
Well, this is a very interesting issue, because I think if an employee has their own vehicle, then they are the only persons who can make decisions about how they maintain their vehicle, how much they spend on their vehicle, what they do with their vehicle. Organisations and businesses have exactly the same control over vehicles that they own. They determine how they maintain them, how much money they spend on maintenance, etc., etc. The grey area, of course, is grey fleet, when organisations are getting workers to use their own vehicles, and that's why I think it's problematic. What I would say is that wherever organisations can get workers to use vehicles owned by the organisation, they should do so, because at that point the organisation does have control over ensuring that the vehicle is safe, is properly maintained, is properly upgraded when it needs to be, and they can demand a worker not use that vehicle belonging to the business until it has been properly maintained. They can't prevent a worker from getting in that worker's own car. And I think this whole seminar has really highlighted that's the issue, this issue of control, that the further away the vehicle gets from ownership of the business, the least control they have of it, and so it's very difficult to manage those risks appropriately.
Great point, Tanya. Let's move on in.
So now I want to touch on criminal and civil liability briefly. There are, of course, offences under the Work Health and Safety Acts, offences in relation to reckless conduct or failure to comply with duty. And I think increasingly in the area of corporations law and compliance, the courts are demonstrating, and the regulator are demonstrating, that they are prepared to look at the actions and intentions of individual directors. It's beyond the scope of this seminar to launch into all of that, but it is possible in certain situations where there has been very reckless behaviour that there may well be some criminal liability that attaches directly to directors. If we think about civil liability, so non-criminal legal liability, issues around foreseeability of harm become very important. So what is it that particular organisations or managing directors or owners knew about what the risk of harm was, and then what was their response to that foreseeable risk of harm? And there are implications here for thinking about assessing risk and managing the risk and taking precautions. So thinking about, at some point, taking a stock take of what vehicles are we using, what can we foresee might be a problem as a result of those vehicles' use, how can we manage that risk and take precautions? The law doesn't require a standard of perfection, but it does require reasonable care, and that's linked very closely with how foreseeable the harm was and what type of harm could be foreseeable. The other important issue here in the context of civil liability is, I'm sure, an area that most people would be well aware of, in business, and that is the notion of vicarious liability, where even though an employer has not committed some wrong act, nevertheless they are held liable for the wrong acts that their employees might be committing. So again, it's important for organisations to think about what does use of their own vehicles by workers, but for work purposes, what risks of harm does that create? How can we prevent those workers from committing wrong acts, whether that's negligent driving, whether that's breach of the road rules, whether it's breach of other road traffic offences? What harm might be caused, and are we at risk of being held responsible for that harm because we were requiring workers to take that action, or requiring workers to use those vehicles, or requiring workers to meet travelling times that weren't safe? So all of these issues can give rise to personal and corporate liability, and it is important in this day and age to recognise that liability might attach not only to the business, but to individuals who are responsible. So an interesting emerging issue in this context is, what if a business knew that their workers were using their own vehicles for work purposes, so the classic grey fleet, and those vehicles were the subject of a vehicle recall, and I'm thinking here recently of the Takata airbag recall, but the workers hadn't got the recall related fixes yet carried out, and yet were continuing to use those vehicles. So at that point, we have clear foreseeability of harm. So a recall like the Takata airbags was very publicly disseminated. There was information about risks of harm for continuing to use vehicles with those airbags, potential risk of injury to drivers and to others, passengers. Now, if a business knows about that, they can foresee a risk of harm if those vehicles continue to be used. And yet they're in this very interesting situation where, do they have control over whether or not the worker uses that vehicle for work purposes? They have no control over what their worker does in their own time, but they do have control over whether the worker uses that vehicle for work purposes. And so I think it's very important to be alert to those issues that are widely publicised in the media, and ensure that organisations take action to at least communicate that to their employees or workers, and then also suggest to those workers that they should not be using their vehicles until those fixes have been carried out. Another emerging issue is around this area of data. Now, data, I think, has been described now as being the new oil for the 21st century. And almost every week now we see the importance of data in many, many different contexts. We've already talked about the importance of keeping really good records, and thank you, Darren, for making that point. What if a business requires workers to keep data about the use of their own vehicles for work purposes, and that data revealed a risk of harm. So, for example, an organisation might require a worker to keep data about how many kilometres their vehicle is travelling. They might pay them. They might even pay them some vehicle allowance or travelling allowance for that. But what if that data then shows that the worker has not been getting that vehicle serviced regularly, or shows that that vehicle has no safety features, and yet the organisation is requiring perhaps a young driver using a very old car to travel very significant distances in the country? Again, we now start to have a much stronger case around foreseeability, where we have businesses who can clearly now foresee a risk of harm because they have the data, they're requiring it to be kept, they ought to now know what that data discloses. And so that raises the possibility of a requirement on those organisations or employers to ensure that that risk of harm is minimised, that precautions are taken. And another very interesting privacy and vehicle data question is, what if a business required workers to keep data about the use of their own vehicles for work purposes, and that data revealed personal or confidential information about that worker? Now, really, really tricky question here is, what if that data revealed that a particular worker was regularly visiting a brothel on the way to dropping the night's takings at the bank, or on the way to the post office, or on the way to doing some other work business? Very interesting privacy issues now around what is personal information, what is confidential information in this context. Increasingly, late model vehicles are keeping and generating vast amounts of data that perhaps drivers of those vehicles are not even aware of, and where you've got sat navs or other things in the vehicles that might keep a record, GPS record of where vehicles have driven, that can reveal very personal information about workers. It might reveal religious affiliation, it might reveal political affiliation, it might reveal that they are regularly attending an HIV clinic, for example. And so how is a business going to manage the private implications of that information? How are they going to ensure that they can comply with their privacy obligations? These are something that is going to be very, very interesting. And I've just noticed a comment that's come through on the chat here, possibly picking up a bottle of wine on the way to work, or having an affair with the CEO's wife. Yes, well, potentially data can reveal enormous amounts about us, and the more data that's being generated every day reveals even more about who we are. And so these are going to be issues for organisations to think carefully through. Again, I think it's much easier for an organisation to require data to be kept and to manage that data when it's about use of the vehicles owned by the organisation. As soon as we have workers in their own vehicles, the whole issue becomes a lot more blurred and potentially a lot more problematic. Any other questions, Jerome?
Certainly got a great couple coming through here. So one here from Janelle. So in a position description, when it says must have own vehicle, should that say in the future must have own vehicle operating at blah, 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 sort of safety levels, age, etc.?
Well, it may. That is something that would be worth getting advice about, whether or not there are any implications there for discrimination. Are we saying we're not going to employ someone who doesn't have their own vehicle? Are we not going to employ someone who's not wealthy enough to have a particular vehicle like this? I mean, those are things I think that very careful legal advice should be sought about, yes.
And one of our online questions has come through. Should mandatory training and assessments be done with drivers using vehicles for work?
I would support that. I think that it is important for organisations, employers to know that their workers who are using those vehicles can drive them safely. Query is citing a valid licence and understanding the implications of any conditions. Is that enough for that assurance? Are there specific contexts for vehicle use that would require some extra training? Again, that's going to be very context dependent. It might be that if you're requiring someone to do a lot of rural driving, they might need to have particular training about driving on dirt roads, for example. If you are requiring someone to do deliveries out of hours to personal residences where there might be issues around personal safety, I think it would be appropriate to train those employees into how to manage those risks and how to reduce them. So again, very, very context dependent.
I guess for those who don't know, where NRSVP is actually holding a workshop looking at the grey fleet, so actually helping organisations work through these sort of risks and come up with their own sort of internal solutions as part of SafetyScape on the 23rd of May. So if you want more information on that, please go to our website. And just sort of drawing on that, do organisations need to ensure grey fleet drivers produce evidence of maintenance every 6 months? From Janelle.
Well, I can't give you an answer to that because the law is not clear. So, and this is the problem. This is the problem with this whole webinar subject, is that the law is not clear. So this is about thinking about, have I identified and assessed a risk to my business, i.e. that I have workers who are using their own vehicles for work purposes? That's a risk that we've now identified. We've assessed how many of those workers there are and how often they use those vehicles. Now we have to move to step 2 and think about how we might manage that risk and minimise it. And it might be appropriate that you move people out from their own vehicles to other vehicles, or you might say, well, we can't do that, but these are the measures that we're going to put in place to minimise that risk. And that might include sitting down, talking to employees about maintenance of their vehicles, putting in some record keeping. And I know that that starts to feel very onerous on organisations, but it is worth thinking about at this stage before the problem arises. Whether it's 6 months, whether it's yearly, that's going to be an assessment for you with your risk management people, with other advice that you get.
I've got a comment here from Darren just highlighting the importance. If training is going to be made mandatory, ensure that evidence of what type of training is being delivered has an effect. So be very, very effective in that sense. So a question. And
you need to make sure that you're training for the problem that exists, not for some other problem too.
Exactly. So a question here just quickly from Tim, because we have to wind this up in a second. For Takata, the issue is being communicated. Vehicles are not grounded and the scale of recall is major. What happens if an incident occurs before parts and booking for replacement can occur? Is continued use reasonable?
Well, what's reasonable is never sure until a court looks backwards at a situation and determines that it is or it isn't. It's going to be highly context dependent. And I think, again, it's going to be about identifying the risk, really clearly assessing it, and then thinking, what are our reasonable responses in relation to that risk? I'm sorry that I can't say, yes, you should do this, or no, you should not do that. I simply can't. And it's going to be about managing that risk in the context of all the other factors.
Excellent. Do you want to move on now? Thank you, Tanya.
I'll move on quickly because we're almost out of time. I'm not going to spend a lot of time talking about the heavy vehicle national law, but it is important that organisations are aware that where workers are using their own heavy vehicles, it may well be that they will still be regarded as within the chain of responsibility. There are some changes to the heavy vehicle national law that are on the horizon. Things for organisations to think about are they ensuring they're complying with the law? Think about vehicle standards and maintenance. Travelling times, again, is very important in this context. Driver fitness and safe practices. And if you're working in the heavy vehicle space, you will be very familiar with this HVNL already, but I just want you to think about it now in the context of people who are using their own vehicles. All of my previous comments largely still apply. So just to finish off and to summarise what I've been saying during the course of this webinar, whether or not ultimately there would be any legal liability is very much dependent on jurisdiction, legal context, wording of very specific legislative provisions. And that's going to differ across those jurisdictions and contexts. We know, however, that workplace includes a vehicle. We know that employers and organisations have duties to workers and others. This is about thinking about how organisations can do the right thing and minimise risk to their workers. And these notions of what's reasonably practicable and reasonable precautions can provide a general guide for prospectively assessing risks. The takeaway, I think, from today is that now is the time to take grey fleet issues seriously. You don't want to be the first organisation who's facing legal claims in relation to grey fleet, and people who are injured in this context who aren't eligible for existing schemes may have more incentive to consider exploring some of these issues. So take the time, now's the time to take your grey fleet issues seriously before they're a problem. And I hope this has been useful.
Well, thank you very much for your time today, Tanya. Thank you to our engaged audience for asking all those fantastic questions. Please do reach out to us if you want any more of these answered, and I will share those couple with Tanya and see if we can come back with you some more sort of answers. So it only is made as well as those who ask questions. So please visit our website, NRSVP, register for our newsletter, and you'll be kept up to date with all the future upcoming webinars and material we have coming. Have a lovely day. Thank you. And thank you, Tanya.
Bye-bye.